Introducing Jason Morris, an often sought speaker commonly seen in industry events that revolve around background screening, hiring, or staffing. Jason was the co-chairman of the NAPBS in the year 2005 through 2006, during when he made frequent presentations to government agencies, including members of the U.S. House of Representatives and the U.S. Senate. We are proud to present Jason Morris, Managing Partner at Morris Group Consulting, who will present on the topic, The Changing Compliance Paradigm in Hiring.
Hello, everybody. I think everybody can hear me now. Hope everybody's having a great day, and to our friends in India, having a very happy Diwali this week. My name is Jason Morris, as the video said, and for the next half hour or so, we're going to talk a bit about the background screening landscape and some compliance things that are going on and have been going on for the last many years. So with that, let's go ahead and dive in. Today, we're going to again talk about pre-employment background checks and some of the laws and regulations that surround the industry today. And we're going to start with some of the most commonly used acronyms. If we can go to the next slide, please. So there's a couple of different terms and acronyms that we commonly use within the industry that you should probably familiarize yourself with. The first is Consumer Reporting Agency, and that is basically what every background screening firm is categorized as, and we call ourselves CRAs. Then we have end users. We have the Fair Credit Reporting Act, data furnishers, Consumer Financial Protection Bureau, and the Federal Trade Commission, the FTC, and the CFPB. Those are the two agencies that oversee the FCRA. We also have the Equal Employment Opportunity Commission, the EEOC, and the Professional Background Screeners Association, PBSA, which was formerly NAPBS. So let's go ahead and start, and let's talk a little bit about background screening and what background screening is and some of the important workflows that are contained within the processes of doing a background check. And we'll dive into this a little bit more on the first two as far as how the FCRA comes into play with that. But the workflow that kicks off with any background check is getting the candidate's consent. We get a signed release, which we call disclosure, from the applicant, as well as giving them a copy of a summary of the rights under the Fair Credit Reporting Act. And then we obtain information from the candidate. So we might either obtain it directly from the candidate through a portal, or it might come through, to us directly from the employer, either through their applicant tracking system, or possibly they would have loaded it through the background screening company's website or whatever. And then the background check is conducted, which I'm minimizing and simplifying right there. There's a whole lot that goes into that, and then we report the results to our clients. So there's two laws. There's three different areas of the law actually that pertain to the background screening. If you go to the next slide, please. That is the Fair Credit Reporting Act, the FCRA, the Equal Employment Opportunity Commission, the EEOC, and those are some mandates and rules that are set forth by the EEOC that's important for the end users to follow. And then we have a myriad of different state laws that come into play with compliance. There are 50 states in the United States, and several of them have laws that prescribe what a background screening company can and cannot do, and what an end user of the information can or cannot use. So, you know, we have this really interesting web of compliance protocols that we have to follow, but some of them stop with us and start with our client, our end users. So it's important for our users to familiarize themselves with some of those state laws. Some of them are quite easy. Some of them get a little more complicated, pertaining to where the person might have lived, or maybe where they're working, where the company's located. So for instance, if somebody lives in Ohio like me or in Cleveland, and they're applying for a job with a company in California, but I had a previous offense that happened in Texas. So there's there's three different laws that might need to be applied there when reporting information, and that's what a background screening company is there to guide our end user clients for. So if we go to the next slide, let's talk about the risks. The reason that background screening even exists today is because of an uptick of negligent hiring lawsuits in the mid 90s. We also had a lot of workplace violence issues, which actually enhanced the industry. But the risk for end users and CRAs would be those negligent hiring lawsuits. And the basis of that is if an employer could have known, they should have known. And that's where the suits are coming in. And then we have things like unfair hiring practices. We're seeing an uptick, a very big uptick in FCRA and technical violations of the FCRA and plaintiffs' attorneys suing on behalf of those classes of people. So there's been lots of class action lawsuits in the last 10 to 15 years, and it's increasing significantly. We're seeing a lot of EB claims coming out there right now. And all kinds of other technical violations all over the place. And then we have the ever evolving patchwork of state laws, which I discussed before. It's just one of those webs of information that you have to really make sure that you're dealing with people that know what they're talking about and people that understand the compliance laws in those different states, as well as you as the employer or the employers out there making sure that they understand their rights and responsibilities in each one of those states. And then we have consumer data and privacy, which over the last 10 or so years has become even more important, especially if you are sharing information outside of the United States or have clients that are outside the United States. There's all kinds of protocols that have to be followed in that regard as well. So the next slide, we're going to talk about some of the primary services that we offer. Now, as background screeners, we probably offer, I bet there's over 30 or 40 different types of searches that we offer. These are the most common ones. And in some instances, I'm going to put these things in different buckets. You can kind of understand where those reside. So with the criminal record searches, we have probably 3 or 4 different ways of obtaining criminal records. We have things at the county level. We've got things at the state level. We've got things at the national level with some national databases, and we have federal courts, which we're also able to access. And with the federal courts and the state courts, those are 2 completely different types of records that we would find from those sources. And then we have identity and credit solutions. So one of the first things that we do when we kick off a background check is validate that the person is who they say they are, and we obtain addresses of where the person's lived and sometimes worked or went to school over the last 10 to 15 years. And we're going to actually search for criminal records in those jurisdictions. And of course, with that, we can also do what's called a pre-employment credit report, which would identify some credit unworthiness for some positions. We do motor vehicle record searches. We do resume verifications. Resume verifications also include sometimes calling the employer and validating that they had the position that they say they had, and the salaries are in line in the time that they worked there, and there's no gaps of employment. We also do substance abuse testing, sanctions and licensing and exclusions for certain positions and professional licenses. We can validate if they do have those licenses or not. We also have the ability to do background checks in over 230 different countries. A new tool that is in our war chest is social media checks, and we'll talk a little bit about that later and how that is increasing. And then we're able to do some E-Verify and I-9 things under some federal and state laws here in the United States. So the first thing that we're going to talk about, and we'll talk about this in a couple of different ways, is the Fair Credit Reporting Act. So the Fair Credit Reporting Act is the federal law that really governs not only how we operate as CRAs, but how our end user clients use the information or do not use the information on their applicants or against their applicants. And there are rights and responsibilities all the way around. So we have to make sure that we're in line and following the FCRA and guiding our clients as well. So the FCRA it's been around for 40 or 50 plus years. But it was in the mid 90s that it really rolled background screening firms into some of those laws and regulations. And that was enforced, and the rules were made by the Federal Trade Commission, the FTC. In the I think it was around 2010, maybe a little bit after that, after the financial crisis, the Consumer Financial Protection Bureau was created to oversee the banks and financial institutions. Well, it also rolled in enforcement of the FCRA. So we actually have dual authority on the FCRA, and that's by the FTC and the CFPB. So it makes it a little bit confusing, but we at least know what some of the rules are, and they're pretty forthcoming with that. The first step that has to be done under any circumstances when you're doing a background check is notice and consent. So what we have to do is we have to get a signed release from the applicant. That can be electronic or on paper, but it must not be confusing. It must not be, sitting in there with a bunch of other paperwork. It's got to be a separate disclosure from the application or anything else. It can't be stapled. It's got to be completely separate. And that gives the applicant an opportunity to see exactly what their rights are under the FCRA. So they're going to provide them with notice, which is the document from the FTC that goes along with their release, and then they sign that release. Then we have different types of information that we are able to report or not report under the FCRA. So we don't report things, arrests that are older than 7 years under FCRA guidelines. We don't report those at all to our clients. And typically typically we're reporting records that are within 7 years history. If there is information that is going to be used against that person, then there's a process called the adverse action process, which I'll talk about a little bit more in depth here in a minute. The applicant then has a right to dispute any information that comes back on their background check. And they're going to have complete clarity on that because they're going to receive a pre-adverse and adverse action letter from us. And then some of the rights that they have under privacy. So there's a question that just came up. What are the key component mandates? What are key compliance mandates a typical employer needs to keep in mind when recruiting across continents? So I can't really speak to that because when it comes to recruiting, that's kind of where our job, we haven't even started yet. So that would probably be more of an HR question. But the mandates that you would have to follow as a U.S. employer are pretty clear under the EOC and FCRA. So some of the other things that have to be followed under the FCRA would be, and this is the employer's responsibilities, they have to have permissible purpose. Aside from getting you to sign a release or an applicant to sign a release, they actually have to have a purpose to do that. That could be anything from the underwriting of insurance to extending credit or to extending a job offer to somebody. The user, which would be the employer, must provide certifications to the applicant, and they must also certify to their background screening company that they're obtaining a release, and that's usually done in a couple different ways. The term adverse action, I want to talk about that for a second. Adverse action would include really anything that a consumer reporting agency would do, but for employment purposes, it's affecting anything that would affect the consumer and have a negative impact under Section 603 of the FCRA. So if we're going to deny employment to somebody, then what we're going to do is we're going to go ahead and send them something called a pre-adverse action letter. And with that letter is going to be a copy of their report and a summary of the rights under the Fair Credit Reporting Act, so they can see if there's anything in there that maybe doesn't make sense to them, or something that that might be they might want to dispute. Sometimes it's not a perfect system. Background screening is not a perfect system. Criminal records can not only be confusing, but also sometimes they don't get filed properly. Something might get pled down to a misdemeanor, but it's still filed incorrectly at the courts as a felony. So there's an opportunity for the applicant to go ahead back and dispute that. Now, after a set amount of time, usually 5 to 7 days, if there is no dispute that comes in, then the employer would send something called an adverse action letter out to the applicant again, letting them know that they're not going to be hired based on what's in the background check. They also have an opportunity to dispute after that fact. It's a good practice as well to, when they send that letter out, to also send another copy of a summary of the rights under the Fair Credit Reporting Act. So with that, let's go to some of the identity and credit solutions. Like I said before, we're going to do something called a social security trace, and that's going to identify all the places that the person has lived, worked, went to school, and we're going to go ahead and search criminal records in those counties. If you go to the next slide, the information that is required for that is the applicant's first and last name, their middle name. I don't know, I must have left it off here, but we also require their date of birth and their social security number. And you go to the next slide. This will kick off what is called the criminal record process, basically. And there are many different ways that we obtain criminal records in the United States. The gold standard today is that we are going to search the county seat based on those addresses to identify any criminal records in any counties that that person has lived, worked, went to school in. The county seat is the most accurate way to do it. It's where the records are held, and it's where we're able to find the most information on our applicants. That information is usually filed by their name and their date of birth. The next way that we're searching these is through the state criminal record repositories. Some states, not all, have state repositories where those counties kick up those records to the state level. The problem with the state criminal records is there's no mandate in most states saying that all the information has to be updated into the state level. There's nothing saying it has to be done on any consistent basis. So in some states, we'll have records that are, could be a year old with no updates. So we don't know if information is accurate at the state level. And then we have federal criminal record searches. That's anything in the United States that would be investigated by a federal law enforcement agency, like the DEA or the FBI, or certain specific crimes that fall under federal jurisdiction, like kidnapping, extortion, or other white-collar crimes. The hit rates on those types of searches are very low, but it's an important search to add if you are if you're hiring for certain positions. Then we have a national criminal database that we're able to access. Those are usually covered between 8 and 12% of criminal records in the United States, but it's a nice complement to doing the county criminal record searches because sometimes we find other things we might not have found otherwise. Then we have fingerprint checks in the United States, which are wholly inaccurate. We can access sex offender registries, and we can also access civil record searches, which would be anything that somebody be sued for. If you go to the next slide, in the county seat, I'm going to just focus on this a little bit. There are 3 ways that searches can be conducted. Some are instant, and you can get them back, just like that. Or some of them could take a little bit longer. So the first way is we actually physically walk into the court, walk up to sometimes a terminal, and we'll put in all the names and dates of birth of the people that we are searching to see if there's a finding of a criminal record in that jurisdiction. That process is really, when I started my business in 1999, we had 3,000 people that walked into the courts for us on a daily basis that were contractors for us. Today, there's maybe 20% of the courts you still have to do that. A lot of times that we can use something called automated research, which is a lot of the courts have internet portals or subscription-based portals that we can access in it, which is the same as accurate or sometimes more accurate than walking into the court. A lot of us have built automated tools so we don't have to sit there on our computers and type it into the website. There's automation built into that, so we can do hundreds at a time, all through the computer systems and through the bots. And then we have something called clerk run searches, and these have become very, very difficult during COVID because the courts have been shut down, and a lot of the courts have a very slim staff in there. So with a clerk run search, we actually have to walk into the court, and we have to either fill out a piece of paper or give somebody a list of all the searches we want to run, and then we're at their mercy to get that information back. So sometimes we can get that information back very, very quickly. But in other circumstances, we got to wait in line, and we can only turn in 5 names at a time, and we go to the back of the line and we turn in 5 more names. So some of them are, again, some of them can take a long time. Some of them are a little quicker. During COVID, the clerk run searches have been a nightmare. And a lot of times also with the clerk run searches, we also have court fees, which can make the search more expensive. So now back to the FCRA. The required data for these criminal searches would be the full name, The date of birth is the most important. Social security number in some instances we can use as well. The next slide, back to the FCRA, we have rights and responsibilities as background screening firms to make sure that the information is accurate and up to date, and make sure that it is, belongs to the person that that we're searching. So under FCRA law, there is section 613, which talks about two ways that we can ensure that the information is correct. And if you go to the next slide, the options are maximum possible accuracy or contemporaneous notice. And what we've seen today, if you go to the next slide, please, is both need to be done. So under the maximum possible accuracy, I'll call it doctrine, we have to make sure that we're going to the primary source for the records and making sure the information is up to date and accurate. And it used to be that you could do that, or you could send a 613 letter out to the applicant saying, basically, hey, we did a background check on you. It might be accurate, it might not be accurate, but here's the report. You can dispute it if you want. What we've seen in the last 5 or 6 years, or maybe even longer, is a push for background screening firms to do both of these, which means we're obviously ensuring that the information is accurate and up to date and we have maximum possible accuracy, but we're also sending out that 613 letter as well. And we're covering all of our bases in that regard. We're seeing we're seeing most CRAs doing that today and finding that an effective way to skirt some of the lawsuits that are coming out. So I want to wrap things up today. There's a couple of questions, but I wanted to wrap things up with the EEOC. And for a lot of years, and I've been a consultant to the industry for the last 3 or 4 years, but I owned a background screening firm for roughly 17 years, and I've been in the industry for about 30 years, or 25 years. And the EEOC criminal record guidance came out in March of 2012, and I keep calling it the new criminal guidance, but it's not new anymore. It's 8 or 9 years old at this point. But it lays out some things that employers need to really keep in mind, and some processes they really need to follow in order to avoid, I'll call it EEOC interference in their background screening program. So the EEOC it's really there to make sure that employers are not discriminating against job applicants. And they want to make sure that there's no disparate impact against minorities and that there's no overt discrimination. And we've seen it, over the last 30 years. There's employers that have put some really stupid things in job ads, like criminals need not apply, stuff like that. And it's almost created a protected class of people that are ex-offenders. So there's a few things that the EEOC really wants employers to do when it comes to conducting the background check. And the first is applying what's called the green factors. And the green factors is 3 factors. And they're identified by the Eighth Circuit Court. And they look at job relatedness and how the criminal conduct is related to that specific position. The first is the nature and the gravity of the offense. The second is the time that has passed since the offense or conduct or completion of the sentence. And the third is the nature of the job held or sought. So as an example, for the second one, employers should also consider the amount of time that has passed since the offense and the completion of the sentence. The exact amount of time should be identified in the employer's policies and procedures. So basically, if an applicant had an offense more than 10 years ago and hasn't had any recidivism since then, an employer might be more willing to hire them versus an applicant who's been out of prison for the last 10 years, who's been in and out of prison for the last 10 years. With the third factor, employers should consider the nature of the job held or sought. An employer should not only consider the job title, but also the nature of the job duties. Do they have access to confidential information? Are they handling money? Are they interacting with customers? The job functions, the circumstances under which the job will be performed, and the environment in which the job duties are performed. If it's in a customer's home, or they're driving across the country, or in a secluded building with confidential information, those are things that you want to play that come into play when you're using those things to make a decision. And then beyond that, you also need to make sure that once you receive that record, and if you're going to use it, that you do something called individualized assessment. And basically that's saying to the person, look, I know that you did this. I know we came back in the background check. It was 10 years old. Why don't you tell me a little bit about what happened, what the circumstances were? So, maybe it's something we can look past for you. So you're actually giving that individualized attention to that record and making a decision beyond what's just on the paper on the criminal record. So the individualized assessment is something that should be built into your policies and procedures, and it can be done either through a letter, an email, or a phone call, as long as you are documenting that process. Whole lot more to this, but only in a half hour, I can only cover so much. But the EEOC is something that we're all very conscious of, and making sure that we're attuned to what their policies and procedures are. And there's been a lot of lawsuits, and they're enforcing these things pretty heavily. So with that, we have some questions, but we're out of time. So we'll take those to the speaker's lounge, and I can be happy to answer those for you at the end. I wanted to thank everybody for attending my session. I wanted to thank Neeyamo for having me. This is a great format for this virtual conference. I'm excited about it. And I look forward to seeing everybody soon at a conference in person. And happy Diwali to everybody.